So we're now looking at costs. So the amount of costs, or what they can look at is the amount of costs incurred by the landlord or a manager appointed in association with the exercise of the right to manage, which is a point I mentioned before, that if in fact you're not happy with the cost bill that comes in from the landlord after your right to manage, then they can look at that. And this was something we threatened with the landlord, who sent us a cost bill of £6,500, and we managed to knock about £3,000 off without going to the tribunal. But that was our end game, that we had the tribunal to look at those costs if we didn't come to an agreement. There's also the right to look at the amount of accrued uncommitted service charges to be paid by the landlord to the right to manage company, and I think this was an application that was made in your Regent thing, because there's quite an interesting judgment on that.
Indeed.
Because they had money that they didn't want to hand over.
They did.
So that's something that the tribunal will also look at. You can look at appointing a manager, which is something that we've discussed, and who that manager should be. And I think David has actually got personal experience of being a manager that's been appointed. So that's something that can happen. And also they look at determinations of whether there's been a breach of covenant or condition in a lease. And the reason they have to do that is that you can't apply for an order to forfeit a lease, which means to actually physically take the whole property back, unless there's been a determination by the tribunal that there has actually been a breach of the terms of the lease. Now I have to say, in a residential flat situation, I've never ever had this situation happen for breach of terms of the lease, because it's so draconian to actually get a property back. I've had an order to get a property back where there's been service charge arrears, and then they've paid them on the day of the hearing. But to actually physically get a whole property back is something that's really unusual. But it's that threat there, and if there's a mortgage company involved, they will be really, really nervous about that. So something to watch out for. And that, at 12:25, is the end of our talk, unless David had anything else to add on those particular points.
I'd just really just be mindful with tribunals. I've been an applicant quite a few times and a respondent on one occasion, and they are bruising for relationships, for residents and for agents, management companies, and it's just to go into this situation with your eyes open. We had one recently where we were successful as the applicant in pursuing service charge arrears from a resident who was a solicitor and hadn't paid from day one, and just decided to fight and not pay anything. And so we went to the tribunal, had to prove 6 years worth of expenditure was reasonable for every single cost head, and we won. There's no dispute. We had the solicitor bang to rights, but it took us 400 man-hours in preparing that case, and it's got to be paid for. And the residents are facing in that building, which is a very well-run building. There's no disputes that we're aware of, and the fees could be £20,000 that we have a right to recover, whether we choose to or not. It's a moral, it's an issue which we'll have to make a decision on at some point. But it's the time involved on all parties is quite considerable. So if there are ways to avoid going to the tribunal, then I'd suggest that you take action to do so.
What was his justification for not paying?
We found on the day that although we had a copy of their signed counterpart lease, they stated that they never signed it. Unfortunately, the tribunal chair looked at this and said, "Well, if you're now saying you never signed it, I'll take possession of the apartment to give it back to the freeholder." And she consulted with her barrister and came back and said, "Well, actually, no, I did." But it was a bruising case nevertheless, and we recovered all the sums owed, but it took an awful lot of time of preparation. It was a 2-day hearing, and every piece of correspondence, email you've ever sent is poured over.
Future reference though, if someone does say, "I never signed it," say, "Okay, put it back," and then suddenly.
Sorry, Thomas, and then Howard.
Just if a leaseholder maliciously causes that kind of damage of legal costs, it clearly has to be borne by the person who's actually causing these incurring these.
The leaseholder in question, she's a landlord. She had over the years some grounds for complaint, and they related to a lift being out of action for a period of time, but there was a reasonable response to that, and so they're very minor grievances. But no, the tribunal decided that the cost should, can be recovered by the service charge, but not from the individual.
Yeah, a similar case where a solicitive leaseholder was kind of playing the game in a way, and we took them to court, and then they dragged us to a South Wales court somewhere. Nobody was prepared to pay for a solicitor to go down there and actually deal with them, and it was more or less abandoned at that stage. But all the costs we had incurred were just sitting on our shoulders now, and it's very frustrating.
Yep.
Howard?
Can I just ask, in that case, just roughly how much the leaseholder actually owed?
£6,000 approximately.
So was it worth spending £20,000 to get £6,000?
Unfortunately, there's no other. It would go on. It had, every time we'd attempted to go through a normal credit control process, it got nowhere. The lady in question was legally trained and seemed to know a lot of buttons to press to prevent it escalating to a court, and we took a commercial decision to say, well, enough is enough. We're now ready to prepare our files, and we made the application, and like I say, it took nearly 400 man-hours to do so, of my time and a few colleagues, but several lever arch folders later, we had a very robust case. And
yeah, but then that's £20,000 to all of the other leaseholders, which has happened on our site as well. Yeah. We had somebody that owed £5,000. Region Management spent £35,000 of our money defending that case, which doesn't make any sense to the leaseholder.
No. But if this would have gone on in perpetuity, there's no end point.
Yeah, but I'm sure that there could have been some mediation at the start to say, look, we don't really want to pursue you in court and stuff. It's going to cost a fortune. It's a lot of hassle for everybody. You just come to some sort of amicable agreement, and I'm sure that they would have, and it would have been in the interest of the rest of the leaseholders.
You might find, I certainly got one at the moment for the scheme I've got the house off, and the guy only ever pays once he's got sued, and he doesn't pay, it's his mortgage company that pays. And so we've got him, and he's been like that since the scheme started in '99, and I think he's a professional landlord and just leaves it to the last minute before anything's paid. So you'll always get those sort of people, and at the end of the day, certainly for us as the management company, we've got to take a stand with those people. So why should they get away with it?
No, I'm saying it should, and saying it's not really in the interest of the other leaseholders that have to foot the £20,000.
But in this, under this new cost regime, if this person, I would say that behaviour potentially is vexatious, and I would have been, I don't know what happened, but I would have been applying for a cost order against that person as an individual. If they hadn't have been, I mean, if it was an older case, the maximum you'd have got against the individual should have been £500.
This was under the LBT. This was
the new regime. If you can prove, if the tribunal consider that person has been vexatious and they've not got home on any of their points at all, and it's been a waste of everyone's time, then the tribunal does have the ability to make an individual cost order against that person in those sort of cases now.
As a leaseholder, that's the way we were going to go.
Yeah.